I call this meeting to order. Welcome to meeting number 86 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. Feedback events can occur. This can be extremely harmful to interpreters and cause serious injuries. The most common cause of sound feedback is an earpiece worn too close to a microphone. We therefore ask all participants to exercise a high degree of caution when handling the earpieces, especially when your microphone or your neighbor's microphone is turned on. A reminder that all comments should be addressed through the chair. Pursuant to Standing Order 108-2 and the motion adopted by the committee on Monday, October 23rd, 23, the committee resumes its study of rights of victims, reclassification, and transfer of federal offenders. I would now like to welcome our witnesses today. In person, Office of the Federal Ombudsman for Victims of Crime, Dr. Benjamin Roebuck, Federal Ombudsperson for Victims of Crime. As an individual, victims, friends, and families, Ms. Chwalchuk, if that's correct, Ms. Murray, and Ms. Penner. Welcome to all of you. Up to 5 minutes will be given for open remarks after we will proceed with rounds of questions. But if it takes a little longer than 5 minutes, I will indulge it. So if we could start now with Mr. Roebuck, please.
Chair, point of order.
Yes, sir.
I don't want to take any time. I just want to get on record. In case any of our witnesses who aren't here don't know why Mr. Danson hasn't, because I think they probably thought he was coming too. He was scheduled and is supposed to be here. His headset did not arrive in time, so we're trying to work that out now. And if it doesn't arrive by the end of this meeting, we'll try and see if we can't get him rescheduled. I just want to put that on the record, and so everybody knows where Mr. Danson is.
Yes?
I just wanted to say I support fully rescheduling if the headset does not arrive in time.
Thank you. Okay, Mr. Roebuck, please.
Honorable members of the committee, thank you for inviting me. We are on the traditional unceded, unsurrendered territory of the Anishinaabe Algonquin Nation, and I honor the leadership, strength, and wisdom of Indigenous peoples, and I accept personal responsibility for pursuing justice and reconciliation. Security reclassifications and inmate transfers from higher to lower security institutions have received recent attention from politicians, the media, and Canadians. My heart goes out to the families who've been victimized and have had to fight for information, even in federal court. These are not new concerns for victims and survivors, and recent debates highlight how victim rights are overlooked. Sadly, the Correctional Service of Canada's transfer review did not even mention the Canadian Victims' Bill of Rights, in part because it had little to offer. While the CVBR has quasi-constitutional primacy over the Corrections and Conditional Release Act, victim complaints to federal agencies are generally deemed inadmissible or unfounded. My office is nonpartisan and operates at arm's length from Justice Canada. Our regulations do not permit us to review transfer decisions, but we are mandated to address victim complaints and ensure their rights to information, protection, and participation are upheld by federal agencies. Rather than assessing if legislation and policies were followed, an ombudsperson operates on the principles of procedural fairness and is intended to humanize government. I'm grateful for the correctional investigators' comments on the need for parity between our offices. We need supporting legislation and comparable resources. Currently, the government spends less than 20 cents on victim complaints for every dollar spent on offender complaints to our respective offices. We know that victims are not put first. And I'm not sure people understand the importance of information to victims of crime. When someone has been seriously and intentionally harmed by another person, it's a common trauma response to need to know everything. Knowing the location of the person is especially important. The transfer review concluded that more could have been done for the victims' families and recommended that CSC create a multidisciplinary working committee. This is underway, and our office is serving as a special advisor to the committee. Also, following consultation with our office, the former Minister of Public Safety issued a ministerial direction to CSC to meaningfully engage and elicit input prior to a transfer to engage with victims of crime. He directed CSC to work closely with our office and the Federal Privacy Commissioner. We have been collaborating well and have made recommendations outlined in our submission to the committee. The same recommendations from our office have been provided to the multidisciplinary committee, and CSC is taking action to implement them. Victim rights and offender rights can coexist. We can do a much better job of providing information while still respecting the Privacy Act. So how do we achieve that balance? The interests of victims of crime need to be given equal weight to the interests of the people who harmed them. It's not just the offender's transfer, the offender's parole hearing, or the offender's release. These are significant for the people they've harmed. So whose information is it? We hear complaints from victims of crime that public servants get to pick and choose what victims are entitled to know and when, even if the consequences of not knowing cause fear, anxiety, post-traumatic stress responses, or interfere with their ability to work. The impact of being told about a transfer as it happens or after it happens is grossly disproportionate to the privacy implications of providing advance notice. The Corrections and Conditional Release Act is failing victims of crime. It limits information excessively, even upon request, and fails to provide protection and participation in ways that make sense to victims of crime. It is in conflict with the Canadian Victims' Bill of Rights, which carries primacy in the event of inconsistency. Canadians are demanding better, and policy changes and amendments to the CCRA could easily achieve that. First, a trauma and violence-informed approach needs to guide communication, allowing victims to share safety concerns without providing traumatic details repeatedly in victim statements. Next, the principles of the CCRA should be amended to explicitly include victim rights to timely and relevant information, protection, and participation. CSC should adopt a more proactive approach to informing victims on pending transfers, including information on how decisions are made and how to share safety concerns or request geographic restrictions. CSC needs a clear, non-discretionary process to disclose information about transfers before they occur, unless specific safety or security reasons are provided in writing in advance. Ensure the geographic location of registered victims is considered in all transfer decisions. An offender should never be transferred to an institution close to victims before they've been notified. Finally, victims need clear information that explains how they can register to be informed about an offender and their sentence, and how to provide input for consideration before decisions are made. It should be clearly emphasized that unregistered victims will not receive information. And to be clear, most victims of crime in Canada with a federally sentenced offender are never informed about a transfer at all because they're not registered. We want a more compassionate, victim-centered approach at the heart of CSC's transfer process. Victims and survivors of crime are worthy of respect and dignity and worthy to receive information. Thank you.
Thank you, Mr. Roebuck. And now I will invite Ms. Penner, Ms. Murray, and Ms. Chwalchuk. As agreed prior to our meeting, take all the time that you require for your opening remarks, please.
Thank you. Good afternoon, Mr. Chair, honorable members. My name is Marcia Penner. I want to thank you all for inviting us here today to be part of this witness panel and to testify on the impact of the moving of Paul Bernardo and all other maximum security prisoners alike. When asked how this move has affected me, my quick answer is, how hasn't it? When I received the news of this move, my heart dropped and 31 years of anguish, anger, fear, and despair rushed in and brought me right back to the day when Kristen was brutally killed. The day our lives changed forever, our innocence was lost, and our naive perspective of the world would be forever tarnished. The day I started to believe in monsters and the harsh realization that true evil existed all around us. The day we realized we were no longer safe. I understand that the CSC, as well as Commissioner Ann Kelly, seemingly followed all stipulated guidelines and regulations while assessing this decision. All necessary boxes were allegedly checked, and criteria was met to accommodate this move. It is without question that a narcissistic psychopath such as Paul Bernardo would have no issue manipulating that system. Someone of his caliber would have no problem composing the appropriate answers necessary to warrant a move to a lower security institution, a transfer that he himself instigated. It is also no surprise that after 31 years of not fulfilling the requirements to warrant a move, he was able to convince the CSE that he could now play nice with other inmates in an institution filled with similar designated prisoners. Prior to the decision to allow Paul Bernardo to remain in medium security, I forward a meta-analysis along with a letter submitted by Dr. Angela Book. Dr. Book has studied psychopaths her entire career and clearly states that Bernardo cannot be rehabilitated. The presiding judge at the Bernardo trial, Justice Patrick Lesage, stated, I quote, "Mr. Bernardo, you have no right to ever be released. The behavioral restraint you require is jail. You require it, in my view, for the rest of your natural life. You are a sexual sadist psychopath," end quote. Does the designation dangerous offender not hold any weight? This man is the worst of the worst. A pedophile rapist, sexual sadist to psychopath, murderer. There are no crimes worse. If he doesn't fit the mandatory requirements for a maximum security stay, then who does? So because he didn't pose any threat to the staff within the jail, he's no longer a threat? So because if he escapes, he's no longer a danger to all of us? What about the victims that he did hurt? He murdered. He stole their lives without any choice. It is also my understanding that Ms. Kelly was quoted as saying that the department, I quote, has compassion for the victims, end quote. I challenge that statement as this decision was made and shared with the Liberal government 4 months prior to the move, as the families were notified the day of. When the government was asked about their knowledge of this, they denied knowing anything about it. It was also reported that any media or public backlash would be taken care of in regards to this move. Is this consideration for victims, for their families? How are we to have any faith or trust in our elected officials when such little to no regard is given when dealing with such a highly sensitive case such as this? When does this end? Each and every time this monster takes the spotlight and gets his face in the media, all of the victims, their family and friends are re-victimized and re-traumatized all over. The victims' and families' voices get heard during trial and parole hearings, but then are muted when it comes to important decisions such as reclassification and reintegration. By moving Paul Bernardo from a maximum security to a medium security facility, you are telling the victims and families that what happened to them is not relevant, that what happened wasn't that bad. And now that he can behave, he will be rewarded. We need to bring justice back for these victims, for their families, and move Paul Bernardo back to maximum security where he belongs. Thank you.
Thank you, Ms. Penner, and whoever would like to go next, please.
Afternoon, Chair and honorable members. I met Kristen French when I was 4 years old, and we were instantly best friends. At that time, 31 years ago, our city had crime, but we still felt safe. The day Kristen was taken will be a moment frozen in time, filled with terror and pain. To this day, never leaves me. From the initial phone calls of if we had seen her to combing the streets searching for her was a trauma I have never healed from. The subsequent 2-week search was agonizing, watching failed lead after lead announced and watching the hours pass into days knowing the outcome was grim. No one felt safe at any time, and life would never be the same. After 2 weeks of a living hell, realizing that she was truly gone forever, the new nightmare began. A trial that seemed to take forever, filled with errors and a deal with the devil to send Paul Bernardo to a maximum security prison. 9 counts are what he was given, 25 years with no parole, and yet it didn't seem even close to what he deserved. At the parole hearing in 2018, the hearing officer stated to Paul Bernardo, "You understanding Your understanding and insight remains limited. It was evident today that you continue to exhibit behaviors that are counterproductive to the development of insight. So, how is it possible there is such a drastic change from 30 plus years of this type of behavior to now showing full signs of collaboration and willingness to change in just 4 months? Perhaps a master manipulator and psychopath, such as himself, has a plan to secure more rights and freedoms that he will access in a medium security facility." While I understand the comment made from the live press conference delivered from Ann Kelly was the CSC needs to be able to manage these dangerous offenders on the inside. But my question is, at what cost? If it is not psychologically possible for a sadistic psychopath to ever truly change, why should he receive the same privileges offered to the other offenders who actively work towards rehabilitation? I do understand he has rights under the Canadian Charter of Rights and Freedom Act, but it is beyond frustrating to witness him be relocated to a minimum security prison. When the CSC moved Bernardo without proper communication and respect to the victims' families, this actually created a new trauma. It literally stunned not only the families and the friends of the victims, but the entire community and caused pure rage, doubt, and disturbance all over again, especially with no warning. There was no time to process, to react, to refute. It also brought with it a renewed fear for the public safety. We will have a more proactive and meaningful discussion with the victims' families, was the response from Ann Kelly. That reply brought more anger and anguish as the families and friends were left in that moment to do nothing but watch. I am here to be a voice that stands up for Kristen. One of my concerns, many concerns I have, is this: are the victims' rights respected at all in these decisions? After 31 years, I can say I have not healed from the horrifying and monstrous loss of Kristen French. There will never be full closure. It changed me forever. It changed who I was, who I became, and it made the world around us a darker place. Knowing she nor his other victims will ever get the opportunity to live the life and the dreams that they should have has always left a profound sadness in our community. All I can do is continue to be her best friend, to offer my voice to fight for justice and the rights of the victims of Paul Bernardo to prevent future tragedies. I plead that you will reconsider your decision to keep dangerous criminals such as his caliber where they belong in a maximum security prison for the entire sentence and for the well-being of our society and out of respect for the victims. Thank you.
Thank you, Ms. Chwalchuk. Can we have Ms. Murray, please?
Thank you, Honorable Chair and members. Given the issues with my microphone earlier, if you're having trouble hearing me, please feel free to interrupt me and I will use Marsha or Tennille's microphone, but it seems like maybe everything's okay, so I'll go ahead. So thank you for having me. For myself, it's nearly impossible to fully express the impact Paul Bernardo and his crimes have had. For us as teenagers, dealing with the loss of our best friend, Kristen French, in such a brutal way was insurmountable and something we have never fully recovered from. At the time, trying to process such horrific events left us feeling immeasurable grief, sadness, anger, confusion, and fear, in addition to the loss of our sense of safety and security. The list of Bernardo's victims, however, is extensive. There are the many other women who were directly brutalized by him, parents who lived in terror that their own child would be the next victim, and the loved ones who watched helplessly as people they loved were traumatized. There were also the first responders who searched and collected evidence from crime scenes, and even the legal personnel, including witnesses, jurors, who had to witness the horrifying images of these crimes on videotapes. In the 31 years since then, so many of these individuals, including ourselves, have developed ongoing mental health issues, including post-traumatic stress disorder, severe anxiety, depression, substance abuse. Some people have also had difficulty forming healthy and secure relationships with their friends and partners and have struggled to raise their own children without the fear and hypervigilance into which we were conditioned. When Bernardo was finally incarcerated and labeled as a dangerous offender, I think we all felt some sense of relief that we could begin to move on from the nightmare. However, almost every year since his capture and incarceration, many of Bernardo's victims, their families, and their friends have been re-traumatized by the reemergence of his name in the news, which inevitably comes with a rehashing of the brutality of his crimes. For many of these people, re-traumatization involves terrible visual and emotional flashbacks, recurring nightmares, dissociation from their lives and their loved ones, severe anxiety, and depression. The latest news of his transfer to a medium security prison was no exception. We are aware there are protocols and guidelines for determining the classification and transfer of prisoners. But one thing was blatantly missing, and that is the careful and real consideration of the impact this transfer would have on all of these people who have been directly affected by Bernardo's crimes. It genuinely appears to us that no one involved in this process stopped to consider, even for a moment, the requests, wishes, or feelings of those people. Even the victims' families were not informed of his move until after it had already been completed. So we are here to demand that the rights of his many victims are considered and respected now and moving forward. We are here to demand that decisions like this transfer and any decisions that have the potential to re-traumatize victims cannot and will not happen in the future without careful and thoughtful consideration of their rights. It is also obvious to us that no consideration was given to Bernardo's original sentencing or to his designation as a dangerous offender in the determination of his prison security classification. Based on his crimes and behavior, Bernardo was originally sentenced to 25 years in a maximum security institution. Harshest punishment possible, and a punishment I think we can all agree at the time took well into account the rights of his victims and their families. However, his most recent parole board hearing in 2021 found that he still displayed no remorse, no empathy, and no insight into his crimes, and which research shows as a sadistic sexual psychopath he likely never will. Therefore, it should follow that his original sentence should still stand. Bernardo is not an average prisoner who may be rehabilitated through programs and support and should therefore be managed by his initial sentence. Bernardo should be moved back to a maximum security prison to honor the original sentence, which so clearly put the rights of his victims in high regard. Going forward, any possible decisions regarding his incarceration should involve consideration of all these factors: his initial sentence, the dangerous offender designation, and perhaps most importantly, clear and comprehensive communication with his victims and their families. We can do better for his many victims, and we must. Thank you.
Murray, and we'll move into questions now. We're going to start with Mr. Baldinelli, please, for 6 minutes, please.
Thank you, Chair, and thank you to the witnesses for being here today, and in specific to Ms. Penner, to Ms. Murray, and to Ms. Chalchuk. Thank you for sharing your stories. I can only imagine how difficult this was for you and how difficult it must be when you have heard of the transfer decision that was made. It must be like a nightmare that you can never escape from, and somehow that's been reflected in the comments that you've made. First of all, if I could, I'll pose this question to all three, if I could. What was your initial reaction, or what was your reaction when you heard the news about the government transferring Paul Bernardo from maximum to a medium security prison. Ms. Chalchuk, I mean, for example, in your comments, you said it created a new sense of trauma under a magnified light. So I was hoping that you could just expand on that, and all three witnesses, if you could comment on that.
Absolutely. In that moment of sitting in front of the TV and realizing that there was nothing, there was no warning, there was just nothing but absolute fear and anguish and tears and rage and everything that we thought that if he stayed in maximum, we might have some sort of peace inside, knowing that he was where he belonged forever and knowing in that moment that it was over. It's so hard to put into words. It was just absolute anguish.
Ms. Penner, Ms. Murray?
Yes, so for me, it was a number of emotions. Everything resurfaced, brought us back to when we were 16 years old and when Kristen was taken so horribly away from us. It left us in despair, a feeling of hopelessness and unjust, feeling like our justice system has failed us again, that how something like this could take place with someone as pure evil as Paul Bernardo. I understand that there are rules in place and there is criteria that has to be followed. I also know that there is exceptions to those rules. It brought forth a horrible sense of trauma and unsettlement. We felt unsafe again. And it is just a feeling that it's very hard to describe, but one that I don't wish on anybody.
Ms. Murray?
Hi, thank you. So as I had said in my statement, that many of his victims, I'm sure, other than ourselves, have developed many different mental health issues, including ourselves. But for myself personally, I have complex post-traumatic stress disorder. And so when Marsha actually called me to tell me, and it really does feel like you are you are taken back to that moment in time and you emotionally feel what you felt when it was initially happening. So, I mean, that is actually what happens when you have a flashback. So essentially it was like being 15 or 16 years old again and hearing about the moment when or feeling the moment she was taken from us, feeling how we felt when she was told that, when we were told that she had been found. And so it really takes you back to that, and it just pulls out all of those emotions that you try to kind of suppress. And so it happens every single time. Every time his name is brought up in the media, this is really the experience for most of us. It's just the re-traumatization, and it brings us right back to that same moment and just to re-experience the feelings all over again.
Thank you, Ms. Murray. Again, I'll pose this question to all of you. I mean, during the period of incarceration of Mr. Bernardo, and then when the transfer decision was made, have you felt heard at all or empowered by, Correctional Services of Canada or the federal government throughout this process? Have your views been listened to? Have they been taken into consideration? Or have you had an avenue to share your concerns? We'll start with Ms. Penner.
Thank you. I feel like I had an opportunity to approach the CSC and Miss Ann Kelly, but unfortunately, I don't feel like I was at all heard. I had resources, as I mentioned in my address, that Dr. Book was very, very kind in providing a meta-analysis as well as a letter for us. We gave her ample examples of why such a move was not conducive to anybody, the victims, the families, the public, society. I have to say, I do not believe that we have been heard. I do appreciate Mr. Baldinelli. I have reached out to you, and quite frankly, you are the only one that has heard us and has taken any action in this to do the right thing and to right this horrible wrong. So, in short, that is my answer.
Thank you. Ms. Murray?
Well, essentially, I mean, the three of us tend to work as a unit, and so we did sort of attack this at the same time together. But further to Marcia's comment, I did actually send some emails myself independently. I did send one to Prime Minister Trudeau's office, indicating who I was and what the situation was and how we were feeling, and did not receive a response, or I think I did. It was a general response. So definitely not feeling heard in that way at all. And as Marcia said, our email to Ann Kelly, we did receive a response. We were not satisfied with that response, but we did receive one. But for yourself, Mr. Baldinelli, you've been wonderful. Mr. Polyev has taken a wonderful interest in this. And I will say, actually, personally, when the three of us were at Ottawa, we really felt heard. He gave us his undivided attention and very much listened and seemed to hear what we were saying while we were speaking. So we really appreciated that. And there have been other members of the Conservative Party, Michelle Ferreri. I've been corresponding with her actually quite a bit through email. She is a wonderful advocate. She listens to us. She hears our concerns. And so I really actually just wanted to say thank you to those individuals as well.
And Ms. Chalchuk, if you could, and then I think my time is done, correct?
Thank you. They have both touched upon, and again, we have collaborated as a team on all of this. I did as well send communication through to the Liberals with no response as well, and would also like to say thank you to Mr. Polyev and yourself for being the driving person behind us who is actually listening with your heart and trying to get us somewhere. And that means the world to all three of us. Thank you.
And we're going to move on to Mr. Scheifke now for 6 minutes, please.
Thank you very much, Chair. Ms. Chwalchuk, Ms. Murray, and Ms. Penner, I want to thank you for being here today. And I want to begin by acknowledging how difficult it must be for you to have to relive this to a certain extent and extend the appreciation of all members of this committee, regardless of political stripe. We very much appreciate you being here and sharing your testimony with us so that we can move forward and find a way to do things better. In our last meeting, I was able to address personally the Commissioner of Correctional Services Canada, Commissioner Kelly, and I shared with her my gratitude for the work that she's doing to ensure that Canadians are kept safer, 20-year low in prisoners escaping from correctional institutions in this country, which was good news. But I also took the opportunity as a father, as a brother, as a son, as a member of this committee, as a member of Parliament, my extreme discontent with the way in which one particular aspect of this transfer was handled. And that was the way in which all three of you were treated and informed of the transfer. Without being given a full day's heads up, without being given any possibility of counseling, being able to absorb the news, for me was unacceptable. And I think it's unacceptable for all members of this committee and for all Canadians. And I think the best use of my time and the best use of our time here in this committee is to ensure that this doesn't happen again, and to ensure that whatever we're doing moving forward ensures that victims of the crimes, the likes of which were committed by Mr. Bernardo, are treated with greater respect and the kind of respect that you deserve. And so what I want to ask you today, and this is for the benefit of the multidisciplinary working committee that has been established because of this, is based on the way that you were treated, based on the way that you were informed of the transfer, how should it have been done that it wasn't done? And I'll turn it over to whichever one of you wants to go first, perhaps Ms. Penner.
Yes, thank you for that question. It's an important question and one that we've talked about to great length. I think time, ample time, is very important. Giving the family and the friends ample notice that this is going to happen. That leaves time for processing, questions, rebuke, counsel. Like there's certain steps in which it has to happen, that if a prisoner of this magnitude is being moved, there are certain steps that have to be done in order to facilitate that move and have the family and the victims and the friends ready for that to occur. None of that. I obviously don't believe that this move should have happened, period. However, having had it done, time, notice would have been the least, I believe, that the committee could have done.
Thank you, Ms. Penner. Ms. Murray?
Hi, thank you. Yes, so obviously in agreement with Marcia, one thing I would just like to add is, I think she touched on it briefly, is counsel. So one of my thoughts in regard to the multidisciplinary committee, seeing that it's supposed to be multidisciplinary, I feel very strongly that there should be some trained mental health professionals on that committee who then would liaise with the family and any other victims or friends who would need to be informed of these things, because it really is, it really does re-traumatize. I mean, you had said that you thought that to a certain extent we experienced these crimes and traumas when we were notified, but in fact, I would say that it was almost to the full extent, because that essentially is what happens when you are re-traumatized. You revert emotionally back to the initial trauma. So I think it's really important that there is some guidance surrounding mental health and how to best handle and support family members of the victims or the victims themselves. Obviously, in other cases, that should really be the first concern, is how are these family members and victims going to feel and react, and how can we support them?
Thank you, Ms. Murray. Ms. Chwalchuk?
Thank you. I would say communication would probably be communication and time, as they have both touched upon as well, would be, it has to be the first thing that happens, to give time, to give resources. And again, as Laura touched upon it, I think that getting the victims, their families, friends, anyone who needs it, the mental health backing that they need to go through this again should be made more readily available. Thank you.
Thank you, Ms. Chwalchuk. Do I have any time, Mr. Chair?
You go ahead.
I wanted to ask a question to Dr. Roebuck. At our last meeting, Commissioner Kelly had updated our committee on the creation of the multidisciplinary working group. What do you hope to get out of the creation of that committee? And perhaps could you build upon perhaps what has just been said with regards to the notification, the timing, the resources available to victims, and what you hope that committee will achieve with regards to those actions?
Thank you for the question. To all the witnesses, I'm so sorry for what you've experienced. The way that we are treating victims of crime in Canada isn't just, it's not kind, it's not compassionate, it's not respectful. Our office has made recommendations about notification on prison transfers all the way back to 2010. And they've not been implemented to this point. We're hoping that this is a turning point. What we've recommended is that there will not be any transfers where people haven't been notified at the time of a pending transfer, of that a decision is being considered, how to submit their feedback, how to share concerns, so that they're taken into consideration in that final decision. The current law, what typically happens is that for all transfers to maximum or medium security, victims aren't notified until 2 days after. So the standards that we're providing are very poor. So from the multidisciplinary committee, I think what's encouraging is that it looks like there's an intent on CSC's side to try and address a broader range of issues affecting victims of crime. And I'm hopeful that the concerns that certainly as an ombud for victims of crime that we've been raising, there's many areas like this where we can do better. And we need to pay attention and we need to respond so we're not causing further harm to people who've already been harmed.
Thank you, Dr. Roebuck, and thank you to our witnesses who are joining us by video conference. And I want to thank you in advance, Mr. Chair, for being so lenient with the time today. Thank you.
Ms. Michaud, please.
Merci, Monsieur le Président.
Thank you, Chair. So I also wish to thank you for being here with us today. I acknowledge your courage. I can't imagine how hard it is to relive these events repeatedly and to see it discussed in the media so much. So you have all my empathy. I wasn't able to tell you that directly. I hold you in my thoughts in these difficult times that have emerged again with this study. But with this study that you wanted the committee to undertake in a letter that you sent the committee on October 5th last, you asked the committee to carry out a study to increase the understanding of the public in terms of the transfer of this person, and also to give Canadians better confidence in the system. You heard Commissioner Kelly's comments and the correctional investigator as well. Are you at all satisfied by the discussions that took place? Did it at all bring a balm to your suffering, or do you think it can contribute to reinstilling a sense of confidence for you and for Canadians who were touched by this type of event? And I would like to hear all three of you answer. Maybe Ms. Penner, you could start.
Sorry, I was able to hear everything as that was translated. Fortunately, Marcia and Neil were not able to do that, but so I will attempt to answer the questions. But basically, she was asking if we kind of requested to have this the study undertaken in the hopes that it would achieve some success in terms of informing the public, like better informing the public, all the things we've been saying. And she was wondering if we heard Ann Kelly speak, and she was wondering if we were all satisfied with those comments and explanations, as if they provided to us a sense of being heard and because she understands that this was obviously extremely difficult for us. So I'm not sure if you want to.
He's just, if you want to just check your computer and see if you were under the interpretation sign, maybe that might have been the issue.
Yeah,
But
you know what?
Go ahead.
Is it there now? Sorry. Is it there now?
We can hear
Sorry.
you fine.
Perfect. Thank you. Yes, in regards to that question, again, I apologize that I didn't hear that addressed to me. I do understand, like I had said in my original address, that Ann Kelly was doing the job correctly in terms of the proper criteria and rules and regulations that they have established and was laid out for her. I, however, I don't feel heard. I don't feel that that the decision that was made was the right decision. I believe that he, if escaped from prison, would definitely still be a danger to all of us. I believe that he is a psychopath, a sexual sadist that can never be rehabilitated. And when sentenced to maximum security, that is the facility that he should endure for the entire remaining of his stay. I believe that whether that be a relook at what those regulations are, what that criteria is, what the questions and the testing is on these prisoners needs to be reevaluated. Is that the answer? I'm not sure. I do know that Paul Bernardo is the worst of the worst. It doesn't get worse, and no crimes get any worse than that. And by moving him to a lesser security facility, they are specifically telling the victims and families that what has happened is not that bad. It's medium. It's not. They're re-victimized. They have to go through the whole entire thing again, and it's absolutely wrong. So I don't feel heard. I think it needs change, and I hope that by doing this panel, that will instigate some of that.
Walk, do you want to answer? No? Can you hear us okay?
Sorry, yeah, Tennille is I'm just going to say something quick, which is just that I think when we heard that there was going to be a review of the decision, the transfer decision, provided us with some hope that sanity would prevail, and the committee would find that he was not the model prisoner that should be moved, classification downgraded to medium. So we watched the explanation from Ann Kelly, and when she said the findings of the committee revealed that they complied with all the laws and policies, and that what may well be, we obviously aren't privy to all of the ins and outs of that. But I think what we took from that was she also said that the committee took into account consideration of the victims, and they followed all the laws and policies surrounding victim notification. So that was really where we dug our heels in and said that's where it's going to have to be changed, because the victims' rights need to matter just as much as the prisoners' rights. The ombudsman his comments have been wonderful, and I think he has summed it up so well as to how victims' rights are not heard and in this country, and how they need to be heard, and the steps that this committee is hopefully going to be working towards to make that happen. So really, that's what we're hoping for. I think with this panel and with this new committee, is that the victims' rights will be as equal weight as the offender.
Merci beaucoup pour la réponse.
Thank you very much for these answers. I don't know if the interpretation is working now. Can you hear me? Can you understand me? Perfect, thanks. Yes, the CSC commissioner, after the review, deemed that the decision was in conformity with the established standards, so the offenders, they could check the boxes needed to go from maximum to medium security institution. But would it be those criteria that should be modified? Is that what you're wondering as well? And is that what you're asking parliamentarians to do, to bring that change? Because I think it's important that correctional services has an independence and that they take that kind of decision. Doesn't come from a political level, but maybe those criteria should be reviewed. Do you have any questions about that? Do you have anything to say about that?
So I was just trying to give that to Marcia because she's said it a few times just to us, but that is the criteria as Anne Kelly outlined them for this downgrading of the decision regarding the security classification was there was a statistical component, there was also the clinical component, and of that clinical component was my understanding that there was the ability to manage the inmate, the escape risk, and the public risk. And he came out on the ability to manage as medium, the escape risk as medium, and the public risk as high. So that was nice that was that he was rated as high on that, and that was acknowledged. However, I'll take it to Marcia, but she had said like what it's a public risk is high, whether or not he came out overall as medium, that public risk as high, we would like that to see as being really negating the entire that entire component.
Yes, so further to that, I do believe that yes, if there is a criteria of 3 recommended boxes that need to be checked, if one of those boxes does not fit the criteria for a move or a rehabilitated prisoner, then that move is negated. If this prisoner is still a risk, if he escapes prison and he is still a risk to society, then he's not moved. I believe there has to be more thorough testing. This prisoner has been in jail for 31 years. I think he knows the ins and outs and knows how to work the system and how to manipulate a test on how he can show that he's going to play nice with another prisoner. That to me does not warrant a move. If this is just a lateral move, as Anne Kelly has indicated that this is just a lateral move, maximum to medium, there's no difference, same security, et cetera, then leave him in maximum security where he belongs. I just think that there has to be a more thorough system, more questions asked, more ways that the system cannot be manipulated. And if any of those do not fit, then the prisoner is not moved and remains in maximum security to which he was sentenced.
We're going to move on to Mr. Julian, please.
Thank you very much, Mr. Chair. And I wanted to say to our victims, Ms. Penner, Ms. Tralchuk, Ms. Murray, words can't describe what you have been through, and it is deeply appreciated that you are taking the trauma of the horrific experience to come before this committee to show such courage, to tell us what needs to be changed so that this never happens again. And I think we all deeply appreciate your wisdom that I deeply hope will serve to create change in the correctional system. Ms. Kelly testified this week, and I thought the most important part of her testimony is when she said that the correctional services always takes in consideration information relative to victims when they're taking a decision. And she said, at any moment during a sentence, a victim can present a new victim impact statement to the correctional service. I find that appalling because it puts the onus on the victims. You have lived trauma, and you would be forced, and victims are forced currently, to guess whether or not their victim's impact statement would make a difference in avoiding a transfer that could have significant repercussions. So I have two questions for all three of you, if you would like to respond. First, on how fair you think it is that the onus is on the victims to present a new victim impact statement. And secondly, if you had been given a couple of weeks advance notice that Correctional Services was contemplating this transfer of this sadistic pathological murderer, would you have wanted to file a victim impact statement so that Correctional Services would be aware that the trauma is very real, it exists today, and in that way head off that transfer?
Thank you very much for that question, and I feel very passionate about this. You are absolutely right. First of all, we didn't know that we could submit a victim impact statement regarding this. It had never been communicated. To the best of my knowledge, I'm not speaking on behalf of the family by any means, but I don't believe that anybody knew that that was available to them or us. I absolutely would have done whatever in my power, as we have for the last 31 years, to go ahead and communicate that and to stop this move. I do also want to just briefly say that anybody who has not done a victim impact statement with regards to parole hearings, things of this nature, how difficult that is. So when Ann Kelly and her department put that on the victims and the families and puts the ball in their court, that it's their responsibility now to rebut this, I don't think that they really fully understand what it takes and what it takes out of you to facilitate a victim impact statement and relive from day one to now every single time, every parole hearing, every time something like this comes up, what that takes out of a person and how it re-traumatizes each and every time. So hopefully that answered your question.
Thank you. And I would ask Ms. Murray, Ms. Tralchuk.
Yes, thank you. That, like Marcus said, that's an amazing question. Thank you for asking it, and thank you for acknowledging how difficult this is for us, because it is. However, if we had known, I think that was one of your questions, if we had known prior to the move, would we have done anything about it? Would we have made our voices heard? Absolutely. That is, I think, why we're doing it now, and why we began doing this at that very moment. That was, I think, it for us. I think that it also cannot be on the victim. There has to be other ways to deal with that. And I know, again, the Ombudsman spoke to that a little bit about having the victims be registered and ensuring that they are registered, because that is really what's going to facilitate that communication. So there has to be a way to get those victims registered so that they know that is something they're able to do. I also think that, as Marcia said, doing the victim impact statement is it is in and of itself re-traumatizing. You're going back and revisiting the entire trauma. So again, I'm going to go back to the mental health and say that when Corrections Canada or whoever, or the committee or whoever it is that's dealing with, that's interacting with the victims and their families, there must be somebody who is informed about trauma, because trauma is its own animal. It's very specific. It's very complex, especially in a situation like Paul Bernardo, and the crimes that he committed, and just how horrific they are, because it's just not the same as other as other mental health. So I just really feel that the victims, it should not be on them, and there should be help available to them from Corrections Canada or again from the committee with people who are informed about trauma and who know how sensitive it is in nature and could be there to support them when they're doing these statements. Because I do also think the victim impact statements are very important and need to be heard, but they need to be supported when doing it because it is very re-traumatizing.
Thank you. Ms. Chaltuck, would you like to answer?
Yes.
Yeah.
Yes. So having known prior would have definitely helped. For me, myself specifically, trying to write a victim impact statement has literally turned my world upside down in the last week. So I can't imagine asking that of the victim. So yes, definitely, as Laura touched upon, having somebody there for guidance and to support as they go through this. But definitely, I would agree that the victim impact statements have to happen. They're of the most importance, and I'm glad that we were able to, even if later, that we're doing this now. Thank you.
Thank you. Now, my other question to the three of you is we heard surprising testimony from the correctional officers, from the Union of Social and Justice Employees, that often correctional officers that know the inmates the best are not consulted on the evaluation. The security classification can take place without correctional officers being aware. And often, as I think you've pointed out, the sort of clinical response of a pathological serial killer is going to be different in a formal setting than it may be in the actual prison population. And so how important is it that correctional officers who know these inmates best, who know what their behavior is when they're not being evaluated, how important it is that they be consulted on the security classification and on these kinds of transfers?
Yes, thank you. It's extremely important. The people that are seeing these prisoners day in and day out, seeing the reality of what happens, seeing the reality of how they act, it makes little to no sense to me that they wouldn't be consulted. Like I've said, I know a number of times. I don't mean to repeat myself, but it's not hard for a master manipulator to go ahead and trick the system. He's done heinous crimes, abducted, raped, murdered people. This guy has zero morals, zero accountability. So the people who see him day in and out and know exactly what this individual is all about absolutely need to be consulted. They need to be part of the process and give pertinent information and guidance. Thank you.
Thank you. And now we'll move on to Ms. Thomas, please.
Thank you. Thank you to each of you for taking the time to be with us here today, and again, for taking the time to prepare such helpful opening statements. I realize that's not an easy process to have to think through that again and to have to share your story, its impact here again, so thank you. My first question is going to be for Ms. Penner. In your opening remarks, you made a comment with regard to this transfer taking place without proper notice being given. And then you commented on the government being confronted about this transfer, and the minister at the time denied knowing. You went on to explain that he really did. So he actually tried to mislead the public, which is altogether wrong and certainly has consequences. I'm wondering if you would be able to talk a little bit about the personal consequences that has for you. When someone in a public role professes that he didn't know but then it comes out that actually he did. What impact does that have on you to have someone in a position of trust lie about that?
Thank you. Thank you for that question. And yes, it has had a tremendous effect on me as well as Laura and Neil as well. When something of this nature and this severity occurs, and something that's so deeply sensitive to all of us, and you are left with a feeling of not being able to trust the people that you should. Just a brief example would be, if somebody hurts you or commits a crime against you, and you can't go to the officials to report that because you can't trust them and trust that the information you're giving them is going to give you good resolve. That's it. It's a feeling of, okay, we are relying on you. We need you to be there and advocate for the people in the society. You are our elected officials. We are the ones that are supposed to rely on you, and you're supposed to be accountable to us. If we can't count on you that what you're telling us is true, and that what you're telling us is accurate and in our best interest, then where does that leave us? As advocates for our friend Kristen, and it has been our life mission to fight for justice for these girls and to make sure that punishment is received. It leaves us with a feeling of helplessness. Where do you go? How do we achieve what we're going to achieve if we can't trust the people that are in charge and the ones that are supposed to be protecting us?
Thank you, Ms. Penner. Another question that I have here that I'm hoping each of you can take time to expand on or respond to is, and I'll respond to Ms. Kalchuk's comments. You said this in your opening remarks, that Ms. Kelly, Ann Kelly's response brought more anger and grief yet again. To know he, Mr. Bernardo, may have more rights than the victims he left behind, while the families and friends are left to do nothing but watch, was very disturbing. Over and over again, each of you have commented on the rights of the victim versus the rights of the criminal. And I think you've drawn attention to the fact that there is an imbalance there. The rights of the victims, the commissioner who is here with us in the room, I'm reading a report, and in it says this. It says that the commissioner's directive, CD 705, Section 7, states or outlines the offender's rights to receive the rationale as well as information considered regarding the transfer decision, but victims are not entitled to the same. This inequity is further intensified when considering that offenders can seek redress if dissatisfied. This same right is not mirrored for victims. So there's two things going on here. One, it's being outlined that actually offenders have the right to know the rationale and to be given information with regards to their transfer. But the victims don't. They're not afforded that same right. And then the second thing is, if the criminal disagrees with the decision, he can take redress. There's steps that he can take. But for victims, if they disagree with the decision, or if they're affected by that decision on a very personal level, which of course the three of you have been, there is no redress for you. My question is this: does this speak of a system that puts victims ahead of criminals?
Thank you for your question, and I would say no. To know that if we stand and fight and actions aren't taken and it is stopped in that moment and there's nothing more to be done in that moment, versus the fact that as a criminal, he can constantly but refute, keep trying. And it just seems that there's literally, as has been said, numerous times tonight, there is no balance here. It's almost that the criminal has more of an upper hand is what we're left to see here. I hope that helps answer.
Thank you. Do the other two care to comment? No.
Yeah, I'll just briefly just mirror that. And yes, I believe that the criminal has the upper hand. The criminal has more rights than the victim. We're acting on behalf of our best friend. She didn't get a say in any of this. She doesn't get a say in she's not been able to defend herself in any of this. Everything was taken from her. But yet we are having this conversation and part of this panel today because we have to fight to have this monster put back where he belongs. Fair? Absolutely not fair. Fair that after 31 years, we are still having to relive this and fight for our best friend? Not fair. The system is not, the system, there is something seriously wrong.
We can leave it.
Okay. Thank you. We're going to move on to Mr. Gahir now, please.
Great. Thank you, Chair. And thank you to the witnesses for appearing before the committee. In particular, obviously, I echo the comments that I've made by this committee so far. To the friends and family that are appearing, we acknowledge how difficult this process is. We commend your courage for appearing before the committee. And we also show appreciation for the fact that you are participating. My question, my first question is for Mr. Roebuck. My colleague, Mr. Shipke, actually asked this question earlier, but you weren't given adequate time to answer. We know that at the last meeting, the commissioner updated our committee following the review that she conducted over the summer of the transfer in question. There was a multidisciplinary working committee that was put in place pertaining to the victims. And we understand that the committee has started its work so far. We know that the committee has just started its work, but could you provide us with an update as to what's been done so far?
Thank you. I'll start with acknowledging that my capable team has advised me that I misspoke on the CCRA, and for this whole time, I'm sure government lawyers are cringing. So my deepest apologies. The transfer, I said that for medium and max transfers that victims are notified 2 days after. It's not 2 days, it's after. And they're notified 2 days in advance if it's a transfer to minimum. So I just wanted to clarify that. And I appreciate again the wisdom and experience that you're offering to this committee. Your insights are so valuable, and I'm grateful for the respectful way that the committee is listening and engaging. As for the multidisciplinary committee, you're right, it's fairly new that it's been meeting. It took a while to gather all of the players. There's a plan to meet weekly until I think it's 3 to 4 months of weekly meetings with each topic, each week unpacking a different area of the interactions that CSC has with victims of crime. So like I mentioned, it's much broader than just the transfer piece itself, and it will explore the response to the ministerial direction, to provide notification always in advance. And that's my read on it. And so there have been a few meetings, and it will continue into the new year. This coming week is dedicated to prison transfers.
So when do you think the first recommendations will be made by this committee?
I'm not sure. I know that they're gathering along the way. So my understanding is that at the end of the committee's engagement that there will be a report. But I can say that from what I've seen, that there's work being done already on things that the committee are raising and on recommendations that we've made.
And what do you hope comes out of the creation of this committee?
Oh, I have really big hopes, and I don't know that the committee is big enough, right? I think, it's clear that the CCRA is not fulfilling the needs of victims of crime, and I think it's very clear that victims' rights are so limited in Canada. The CVBR itself, about 30% of the text is dedicated to disclaimers on when the rights shouldn't apply. We have to do better. So my hope is that this working committee can help with CSC's policies, make it more victim-centered, trauma-informed. But there's a lot more work that needs to happen in Parliament if we actually want to take these concerns seriously.
Chair, how much time do I have?
Take your time. Go ahead.
Thank you. So I wanted to ask the next question to Ms. Chwalchuk, Ms. Murray, Ms. Penner. Can you maybe tell the committee about how you think victim services in Canada can be improved? And I think one of the recommendations made so far was advance notice, but in addition to advance notice, how would you want victims to be involved with Correctional Services Canada, if you have any recommendations?
I think that involving the victims and the families in the decision is extremely integral. I think by knowing the full circumstance and the impact of what the perpetrator has done does lend itself to information that perhaps it's not on paper or you're not fully understanding. I think the changes also perhaps, yes, there's testing and there's a system in place and criteria and rules and regulations. My question, I guess, would be, I am not a professional in this. I'm going obviously from a different standpoint than from being a part of the committee, although I would love to be part of that committee. My question is there other could there be exceptions to the rule? Does it have to be cookie cutter for each individual prisoner? I mean, each prisoner perpetrator is a different circumstance. So yes, there's a guideline, but could it be more personalized to that prisoner? You know, I'm not sure the exact answer or what the solution is to perfect the system, but I do believe that communication time, more thorough communication with the people that spend time with the prisoners, more impact from the victims and the families, all of those things combined, I think, is a very important key component to making it so the victims and the prisoners both have rights. I understand that prisoners have rights, and I don't negate that. I don't dispute that. But so do the victims, and those need to be just as important and heard.
Great. I think I speak on behalf of the committee when I say we're very appreciative of your comments. Thank you.
Thank you. I'd like to move on to Ms. Michaud, please.
Merci, Monsieur le Président.
Thank you, Chair. I have 2.5 minutes. How much time do I have? 2.5. Thank you. Mr. Roebuck, thank you for having come here today. Thank you. I know that the lawyer for the families of victims challenged the fact that correctional services gives more weight to the right of the privacy of the offender rather than the information of the victims. So he was deploring a lack of transparency by CSC. Do you agree with him? Do you think that the Canadian Victims' Bill of Rights was respected in this case? Does it need to be strengthened? And how do you see the fact that we talk about the delinquent's right to privacy against as a weight against the right of the victims, that one is more important than the other? What can we do to increase it? I will be answering in English.
They agree that victims' rights don't currently carry an equivalent weight to offenders. And I think there's a problem with how we think about information, that it belongs to the offender somehow. And there's a lack of understanding of how relevant and how important that is to victims and how central it is to their experience. If there's an assessment report that talks about some of the reasons or connected factors to a homicide for the families who lost a child, that's their information, that matters. And we treat it as if all of this belongs to the offender. And so I don't think that the problem is necessarily with CSC specifically. I think it's in the legislation and it's in our collective approach to responding to victims of crime. I think we need to strengthen the Canadian Victims' Bill of Rights to give it meaningful recourse. And we'd like to see, our office would like to see the Canadian Victims' Bill of Rights brought into the preamble of the Corrections and Conditional Release Act so that the guiding principles for victims of crime follow through the rest of the CCRA.
Intéressant, merci beaucoup. La commissaire a...
Thank you very much. The Deputy Commissioner of CSC said that it is important to notify the families of the victims in advance because some considerations have to be taken into account during a transfer, for example, the geographical location. And we were learning through the media that the families were notified on the very day of the transfer or later. Some of them learned about it in the media, from the media. Was the work done properly? If we heard later that someone who was close to the victims lived near La Macasa, could there have been a more catastrophic situation? Now I'm just talking about geographical factors. Are there other circumstances that need to be taken into account?
To clear rights that victims have to protection and participation, whereas the CVBR puts an onus on victims to request information, the onus is on the state to provide protection and participation, and that does need to be better reflected in the CCRA. To reply to what we heard earlier about victim statements, if I can differentiate, a victim impact statement is what's given at court for sentencing. Then once somebody is within corrections custody, there's what's called a victim statement. It's very similar. You can provide details about how you've been affected. You can request geographic restrictions, and you can share safety concerns. And so we've requested that mechanism be streamlined so that people can request geographic restrictions or share safety considerations without having to go through all of the impact on them personally, and that it would carry the same weight without needing to revisit that. So people can submit victim statements at any point throughout the process. They can submit as many as they want. This is what we're told. Don't know what would happen if everyone submits them weekly. I think it's, like we heard, it's impossible to submit it if you don't know that it's required. So within that existing mechanism of victim statements, or even just a streamlined version, we would like to see that advanced notification of a pending decision is given with information on how decisions are made and clear information on how to share concerns or geographic restrictions that can be taken into that decision. I guess finally, currently, CSC will automatically consider any information that they have on file for registered victims. But without updates, somebody might have registered 20 years ago. They might not be living in the same place. We don't know that their daughter just went to university in Kingston, and so people really need to be prompted to share those concerns if they have them so that we can better protect the safety of victims of crime.
Thank you, Mr. Roebuck. Ms. Michaud, can we move on to Mr. Julian, please?
Thanks very much. I'd like to continue on, Dr. Roebuck, in what you were just saying. We know from the surprising testimony, I think, of Ms. Kelly, that the onus is on the victims. And the victims, as we've heard from three very eloquent witnesses today, that the traumatism, the trauma involved in producing a victim statement or a victim's impact statement is enormous. So the fact that the onus is still on the victims is something that I see as a major shortfall in this situation. So I wanted to come back to that issue. For example, geographic restrictions. The Correctional Services is not obliged to follow that, despite it being a recommendation or request from a victim. They're not obliged to follow that. And in the case of Mr. Bernardo's transfer, horrific serial killer, there was no notice given to the victims so that they could actually provide that victim statement and perhaps that geographic restriction. So how do we put in place a system that actually respects victims, puts the onus on correctional services so that victims are truly respected and aren't forced to go through a trauma trying to anticipate when and if an inmate may be transferred?
Yeah, thank you. I think that's exactly what we need, is that there's ongoing communication, that there's respectful consultation on that type of safety information, and too much onus is on victims to know what to do or what to ask for. The CVBR really leaves us with rights that people need to ask about and they don't know that they need to ask. And we don't have an equivalent right up to the charter level, that when somebody's accused of a crime, they're provided automatically with information about their rights, with information about legal counsel, but we don't provide the same to victims of crime. And that's reflected across the country and also in the correctional system, and it's something that we need to change all the way through.
I'll give you three more rapid-fire questions, I guess. First off, the issue that has come from previous testimony from the Union of Safety and Justice Employees, the UCCO as well, correctional officers, that correctional officers are more often than not consulted, even though they may be aware of behavior that may be a higher risk in the evaluation that takes place of inmates. Do you believe it's important to have that additional knowledge and information of an inmate's behavior as part of the prison security classification? Secondly, you've mentioned the issue around the registering of victims. How can we actually make it, again, an onus more on correctional services to ensure the victims are registered, rather than asking victims to try to navigate a system that is often incomprehensible? And then thirdly, both in that regard of registering, but also overall, I thought your testimony around the 20 cents on the dollar, 20 cents spent on victims' complaints for a dollar for offenders' complaints. What is the resourcing issue that we need to resolve so that victims actually get the supports that they need? Is this something that the government needs to contemplate, providing additional resources so that victims are treated with the respect they deserve?
Thank you for that question. I'm sorry, I'm still learning how to address the chair. My apologies. Okay, that's right. Oh, that's a fancy name, yeah. So for the first question, our mandate is limited. We're not able to speak to transfer decisions or how those decisions are made. So I won't speak to that. Number two, on registration, this is part of what our office advocated for with Bill S-12. Which has introduced a mechanism where at sentencing, a judge or the Crown will ask if the victim would like to receive information about the sentence and its administration. And there's also a checkbox added to the victim impact statement. Currently, prior to S-12, there was nobody had that legal responsibility to even provide that information. And so it was haphazard of who would be informed. And we've seen kind of systemic racism in who gets access to that information and who doesn't. So we're pleased to see some progress on that, but we need to do a lot more. And on resourcing, I do think that that's really important. I think in general, we hear complaints from victims of crime that the people who harm them have access to psychologists, or they have access to education training and employment skills training, where that same resource isn't provided necessarily to victims. And so right down to the complaint angle, our office hasn't had the capacity to conduct a systemic review since 2017 because of resourcing, and that's a core function of an Ombuds office that we're unable to fulfill. So I think there's a lot of work to do to provide victims with the type of supports that are going to be more effective in addressing their complaints.
Thank you. Okay, now we're moving on to Mr. Shipley, please.
Thank you, Chair, and thank you to all the witnesses for being here today. I'm sure it's a very tough day for you, and I appreciate you're here and doing your bit for your friend. Mr. Roebuck, I'd like to start with you, if I could. My colleague earlier was asking in regards to Ms. Chwalchuk, and I hope I said that right, opening statement, and I was watching you, and you were nodding your head quite noticeably. It looked like you had something you wanted to add, so I'm going to let you add something here. When she was mentioning, and I'll reread the line, to know he, Paul Bernardo, may have more rights than victims left behind, while the families and friends are left to do nothing but watch, was very disturbing. I was watching you, and you were definitely nodding your head. Looked like you wanted to speak there, and you didn't get a chance. What would you like to say about that?
Yes, I'm quite expressive, so thank you for noticing that. I think absolutely it's true that it's unequivocal that victims don't have equivalent rights to offenders, and even if you look at the government, there's an army of legal professionals that are dedicated to the rights of offenders, to the rights, the privacy rights of offenders, and we have such limited equivalent on the rights of victims of crime. And that's reflected also when cases go to federal court where victims are asking for information. I think it's an important consideration who in government is representing the interests of victims of crime, which is why I think we need to strengthen the resourcing there so that we can do the work to make these rights more meaningful.
Thank you for that. The second question is for you too, sir. The French and Mahaffey families have been trying to obtain recordings of parole hearings and documents referenced in parole hearings for many years, but have been stonewalled by the government. Should registered victims have access to these materials?
Oh, absolutely. I think in the federal court case where they've been arguing for access, the judge noted that it's a shame, essentially, that the media have more rights to access those recordings than the families themselves. And the judge referred it back to Parliament to say that requires legislative change to address that. And so I think we need to do something about that. And I'll say for our office, when we investigate complaints, we require a legislative mandate as well, because we are also denied access to parole recordings that are significant to the investigations of complaints. Though we're working on it collaboratively with the parole board.
Thank you, and I hate to do this because we have very limited time, but I've only got about 2 minutes left. I would like to move a quick motion that I hope gets unanimous consent. I would like to move the motion that the committee extend its study on the rights of victims in crime, reclassification and transfer of federal offenders for one additional meeting to hear from testimony from Tim Danson, the lawyer representing the victims' families. Hopefully, we can hear him on Monday, December 4th.
What's the length? Is it one meeting or 1 hour?
I said one meeting. I did say one meeting. I mean, we have spent, Mr. Danson was prepared for 2 hours today. He did change his schedule a lot to be available for today. I think it would just be right to give him the rights for Monday for 2 hours.
Consent?
Mr. Chair, I think I'm largely in support of the motion, except that I think 2 hours is far too much time. Mr. Danson was going to participate in this panel where he would have shared his time with four other witnesses. I think an hour, 2 hours is way too long for that for him. I'm happy to hear from him, but I think we should limit it to an hour. And in fact, I will make that as a amendment. I would move that Mr. Shipley's motion be amended to be 1 hour.
you, Mr. McKinnon. Ms. Michaud?
Thank you, Mr. Chairman. I agree with Mr. McKinnon. It's unfortunate that Mr. Danson was unable to participate today, but I believe that 2 hours for a single witness might be a bit lengthy, so a meeting of 1 hour would be more reasonable.
Moi, je suis d'accord avec la motion.
I agree with the motion and the amendment. I think it's important that Mr. Danson appear before the committee, and I deem 1 hour reasonable.
Any further comments? Anybody? No? Mr. Shipley? Yes?
I'm a little disappointed in that, but I think 2 hours is appropriate. I think we've been incredibly lenient with our time today, and we have filled this with no problem. I know Mr. Danson has quite a bit to say. I would like to hear him for 2 hours, but it's got to be the will of the room, and I was looking for unanimous consent. That was the original motion. We've definitely given everybody lots of opportunity to speak today. I don't know why we would want to try and cut Mr. Danson short.
Yes.
Mr. Chair, if there's going to be further debate on this, then I suggest we do so after, out of respect for the witnesses that are here, and we still have questions. So to debate this motion now, I think, is inappropriate, and it would be much more respectful to do so after we finish testimony. But if the members opposite, I think we could vote on this right now, but if there's going to be more debate, then I think we have to get back to the testimony.
I agree, and I said I didn't want to waste time on this. I didn't think there'd be any debate. I thought this would pass on unanimous consent. The chair has mentioned we have a hard stop at 6:45. There is no debate on from our side. We wanted a 2-hour meeting.
I think there's a point of order. Yes. I do think there's an amendment on the table from Mr. McKinnon for 1 hour, so I think that's the topic right now. Is there unanimous consent for 1 hour?
Unanimous consent for 1 hour? Thanks, you. Okay.
Solved. There.
We'll move on. Mr. Shipley? Okay. Mr. Shipley is done, so we are moving on to Ms. O'Connell, please. And thank you for your patience, witnesses.
Thank you so much. And thank you to all the witnesses being here. I'll echo what has already been said in terms of I understand and appreciate how difficult this is, and for you to be able to come here and share this with us is extremely helpful. So thank you for that. And it has been very, very helpful to hear your perspective. So it does mean a lot to us, and I do appreciate it. To whomever would like to ask of our friends that are here, because I'll leave it up to you in terms of if all three of you want to respond or any of you. In the testimony that you've all similarly said, actually, you've talked about the need for better communication and more time when decisions are made, and the ability to impact those decisions, but you have to first be notified that something has even been applied for example. And you talked about having people that are available with specific trauma training, and I found this an interesting idea and approach. What's your feelings on, and I'm just thinking about this as I've listened to your testimony, but what would your thinking be on an idea of almost like a support group as an option in terms of maybe not every offender would require something like this. Ms. Penner, I think you talked about the cookie cutter approach, and maybe not every offender and the victims and victims' families and friends would require this. But if there were an option, certainly in a case like this, where there could be additional supports, there could almost be like a support group with trauma-informed services or persons trained in that, as well as people who actually understand the legal system and the correctional system, because part of this, even in our own study, was listening to testimony from the commissioner and really getting clear on what maximum, medium, and minimum, not in this case, but in general, actually means, and how that's different, and the classification process. So I think that piece too would be crucial, not just trauma informed, although that is important. Would something like this, some sort of support group that could be accessed for those who want to, is that something that you might have found helpful? I realize I'm creating hypothetical, but I'm trying to summarize into, based on your comments, what could actually be actionable items that could improve this.
So I think that's a great idea. I think any kind of support in any platform is going to be helpful. And I think it's important to remember with victims that really when you're victimized, you lose your sense of power. You feel helpless. And so to have people there who not only would provide you with the support for the mental health and who are trauma informed, because again, trauma is very specific in terms of mental health, but as you just mentioned, having also people there to help the victims navigate the system, I think it would definitely be very helpful. Victims will feel overwhelmed, and so especially in a system like parliamentary or the correction system, where most victims don't have an understanding of how it works. Many victims wouldn't even maybe know about the victims the rights bureau or section. I didn't even know there was one. So I think that would be very helpful. So some sort of committee that they could access that would provide them with mental health support, but also with the support to help them navigate those systems, and would be very helpful.
Thank you. If anyone else wants to jump in, please feel free, but I'll just add to that. It was mentioned in your testimony between the three of you that you felt voices were muted. And I also can't help but reflect that obviously you three have been, you've come so well prepared and have expressed yourselves so clearly, but at different stages of trauma as well, it might be very difficult for some people to have the courage to come forward. And so having someone also help perhaps speak for them in an event that they aren't comfortable or they're not sure how to express themselves. And I would hate to see voices muted simply because they're not able in that moment that they're experiencing to not express themselves or access the system that is really not designed for victims and friends of victims. So I was just curious if even amongst, I'm sure there are others within your circles of friends too that share in this pain, and you three have come and spoken, like I said, so clearly. So perhaps do you have any experience of others who maybe don't feel as comfortable? I'm sure this isn't comfortable, but in terms of coming forward and speaking up, and how we can make sure those voices are also not diminished.
Yes, absolutely. I think there's a number of people that have been victimized, and they don't have the courage, and they don't have the resources and ability to reach out. And today, being here didn't come easily. It took a lot of buckling down, a lot of phone calls, a lot of emails, a lot of digging our heels in. Luckily, through trauma, there can be some good that comes out of it. For me, it was determination, strength, and stubbornness, and just determined to make a difference. Not everybody comes out of it with that. And I think it's super important that there's resources for people that don't cannot be heard. They can not let their voice be heard. They don't have the resources. I certainly do know some people that are that way. I try to help where I can and guide where I can, but I think something of that nature is super important, and I think would make a great difference. Thank you.
Thank you. Thank you, Ms.
Mr. Chair, I know I'm out of time, but could I perhaps just ask Mr. Roebuck, you mentioned in your testimony you've made recommendations since 2010. Is there any way you could table those recommendations with this committee? Since I'm not able to ask you, I'm out of time.
Thank you. We submitted, in our submission to the committee, we did an appendix of previous recommendations from the office.
Thank
They're
you.
all provided to the committee.
Thank you.
Mr. Lloyd, please.
Thank you, and I want to start by thanking all of our witnesses for being here and for your incredible strength and composure given the terrible context of the discussion that we're having today. Thank you. You may have read a global news report a number of months ago that had an ATIP from Correctional Services Canada's officials discussing the transfer, and you're probably aware of this, but when they were discussing the transfer, one of the officials, they were redacted, said, "When will the families be notified? Does it need to be a few days in advance?" And the second official says, "No, they'll only be notified once the transfer is complete," to which the other official responded, "Oh, good. I was worried that the circus would begin prior to the transfer." And then the other official said, "Nope, he'll be assigned to someone else by the time it hits the fan." Just trying to pass off responsibility. How does that make you feel? And do you feel that anyone at Correctional Services Canada or in the government has been fully held accountable for this callous disregard for the feelings and the rights of victims?
Okay, so it's almost, almost makes us speechless. I can literally feel the energy that just shifted between us sitting here listening to that. I think you nailed it on the head when you said the callous disregard. I'm actually shocked. I think we're all just shocked that someone who works with offenders and understands the magnitude of some of these crimes that these individuals commit would be able to have such a callous and cavalier attitude towards the impact of any kind of decision regarding an offender. I think the other part, it's probably not too shocking that it is a conversation that happened in regards to how this was handled. Because as we had said earlier, I mean, it came out in the news that the Prime Minister's office and the office of Minister Mendicino were aware of the transfer beforehand, and they were aware of the subsequent emotion that would come out of it, and they were prepared for it, but they didn't want to deal with it. They chose to deny that it happened, that they knew, and so, I mean, there just has to be some accountability for these people. So I know some changes were made in the government since then, but it just speaks again to the fact that victims are over and over and over again just disregarded. I mean, this is a man who, the worst of the most terrible things that can be done to human beings, and the individuals who are responsible for his incarceration this is their attitude about it. It's just, I mean, it's disgusting. I mean, there's nothing else to say. So
Thank you, and I appreciate your candidness, and I'll give an opportunity maybe to the others, but just another quick question to think about. You know, Correctional Services Canada and Commissioner Kelly came and said that the law was followed. But in your opinion, if the correct application of the law as it exists leads to people like Bernardo being transferred to medium security, is the law truly a good law? Or is it a flawed law? And I'll just pass that along.
Thank you for that question. And I would answer it is absolutely a flawed law. This is absolutely not the right decision. It was the absolute wrong decision. Yes, I agree that on paper the job was done. The job was done correct, and all the necessary boxes, like I said, were checked. Is that right? No. When you hear of things being said and being communicated and not being communicated, and light being made of something this severe, it leaves you with a sense of, is any of it being taken serious at all? What are the motivations? My questions. What are the motivations? What was the real motivation for this move? I have many speculations. Of course, I'm not on the inside. I don't know. But I highly suspect that there are other motivations that encourage this move. Clearly, there is no regard for the victims in any of that. And flawed law, understatement. Thank you.
Thank you, Ms. Penner. Thank you, Mr. Lloyd. We can move now to Mr. McKinnon, who's online, please.
Thank you, Mr. Chair. I have a number of questions regarding, as a computer programmer in real life, the talk of trauma-informed questioning and process. I need someone to kind of walk me through that. Those are where my questions were going, but I think we're kind of winding up to the end of this meeting. So what instead I'll do is I'd like to ask if the different witnesses have any closing remarks they'd like to make to wrap it up.
Yes, in closing, I want to thank all of you for being here, for inviting us, for allowing us to finally speak, to get our feelings, although not all of them, but to get a majority of our concerns and thoughts. And to all of you, as you all know, we've said this is a very difficult situation. It has been a very traumatizing situation, but we do hold hope that things can be corrected and that this will not happen to anybody else. That is our goal, is to fight to ensure that Kristen always wins and that the victims will always win, and that we can correct the system and make sure that nobody else has to feel this way or go through any of these traumatic things again. So again, we want to thank you all so much for allowing us to be here, and we appreciate every single one of you. Thank you.
Thank you. Ms. Schwalsek, would you like to make any closing remarks? You're on mute.
I as well would like to thank each and every one of you for your most valuable time this evening. For me, I guess the plea is here is just to see change, see a positive change, to see a better outcome for our victims, to make sure that they have just as much right. And I would like to thank all of you for actually making us feel tonight that you're listening, that there's hope that the changes will be made, and that hopefully nobody else ever has to go through this. And in some slight hope, maybe he'll go back where he belongs. Thank you for your time.
Thank you indeed. Ms. Murray?
Yeah, thank you, Mr. McKinnon. So I just want to say really briefly, I am in mental health, so I love your question, but I'm just going to say very quickly that trauma is very complex, and that is what really separates it and makes it different from just simple, let's call it simple anxiety or simple depression or these type of things. So that's why it's so important to have somebody who understands trauma. It is just, there's so many different aspects of it. And I suspect if you start reading, you will fall down a rabbit hole because there is so much to learn about it. And really, I think that's actually very important for anybody who works with victims to understand, because if you are victimized, you are more than likely traumatized. And to understand the victim, you have to understand trauma. So that's probably where I will leave it, because as Tennille and Marcia have said, we thank you and we hope for change. And so anytime you all would like to have us back and have any more input in this process, we are more than happy to do this. And we feel very privileged to be able to be a part of this. Thank you.
And thank you, Mr. McKinnon. Thank you, Mr. McKinnon. Ms. Michaud,
yes.
2 minutes, please.
Merci, Monsieur le Président. Je ne sais pas à quel point c'est pertinent.
Thank you, Mr. Chairman. I don't know if it's relevant to add anything after hearing these concluding remarks. Thank you very much to all of you for having shared your comments with us. Your testimony is greatly appreciated. It's our duty as parliamentarians to take this in and to try to improve the system as well. And thank you to the Ombudsman as well. We talked an awful lot about the imbalance between the rights of prisoners and the rights of victims. And you said that you were hoping that there will be a change, all of this. We're hoping for positive results for the future if your recommendations dating back to 2010 are finally implemented. So I do hope that today's exercise will have been positive and will contribute to putting a bomb on all of this suffering, as you rightly outlined. And we do hope that this same tragedy will not befall other people. Thank you, Ms. Michaud.
Well, and like everyone else in the committee, I've been deeply moved by the testimony today. And I wanted to thank Dr. Roebuck and above all, Ms. Penner, Ms. Tralchuk, Ms. Murray, for your important testimony today. The reality is you've received very little supports over the course of the last few decades, and I don't believe the correctional services and the current regulations have served you at all as victims. And I think we are all hearing that message loud and clear. We appreciate your courage in stepping forward. We appreciate your wisdom. We appreciate recommendations that you've given to us. And we will be endeavoring to work on a report that targets what needs to be changed in the correctional services and how it approaches the case of pathological serial killers in a way that fully respects victims at all times. And I think all members of the committee will endeavor to do the best we can to make the changes so that this never happens again. I thank you for stepping forward to speak to us today.
Thank you, Mr. Julian. And for about 30 seconds, we have Mr. Motz.
Thank you very much, Chair. Thank you again, witnesses, for your incredible courage and testimony. Thank you, Dr. Roebuck. Hearing you today reminds me of something that maybe I would like your quick yes or no feedback on. When CSC begins to consider the downward reclassification of an offender, would it be necessary for CSC to obligate to contact all relevant victims and offer an opportunity to submit a victim impact statement at the earliest stage of reclassification consideration and at least 3 months before any transfer is finalized, and that CSC be obligated to equally consider all factors with reclassification, including victim impact statements? Yes or no?
Absolutely.
Yes,
Absolutely.
please.
Witnesses, I just want to say as chair, your courage and strength in your voice here today. We want to thank you for doing this. I think you can be proud of yourself for what you're doing here today. It's not easy coming on here for any circumstances, but this one is quite difficult. And I want to thank the committee for keeping this very professional and allowing me to kind of go outside the boundaries on timing and things like that. But keep up the good fight, and we hear you. And thank you for attending here today.
Thank you very much, Mr. Chair.
Meeting adjourned.
Thank you very much, everyone.
Thank you.